So without further ado, let's get to today's event. Our topic today is a vast one, and we definitely need more than an hour to do it justice. But given what has happened over the last few months at the federal level, we decided that we could not cover it all. It was completely impossible. So what we would like to do is cover these four topics with you that you see on the screen. Our guests are here to give us insights as well as analysis on the topics, and leaving plenty of time for you all to ask your questions. And what we've decided to do is, since these topics are rather different from one another, we'll pause after the end of each one to give you a chance to ask questions about that topic. So now I would like to introduce you. I have the honor and the pleasure of introducing you to our two guest speakers. First, we have Heather Thomas Lynn. Heather was raised in Shelburne, Vermont. She graduated from Wellesley College and graduated from American University's Washington College of Law. Heather is a founder and managing partner of the Burlington law firm Lynn, Blackman & Toohey. She works with educational institutions on the legal requirements regarding student rights under Vermont's Public Accommodations Act, Federal Title IX, the Individuals with Disabilities Education Act, and other civil rights statutes. She also conducts Title IX investigations and hearings at the college and university level. Pietro Lynn is a graduate of Hamilton College and Boston College Law School. He also practices at the firm of Lynn, Blackman & Toohey. Pietro's education law practice focuses on labor and employment, board governance, and school liability issues. Pietro is an experienced trial attorney, having tried approximately 150 jury trials all over the state of Vermont. So welcome to you both, and thank you so much for joining us and sharing with us your expertise. I'm going to stop sharing my screen so that we can see you all. And the way I'd like to get this discussion going, if it's okay with you, Pietro, is just to pose a question. And my question is, given what we have seen over the course of the first 4 months of the Trump administration regarding its treatment of K through 12 education, what advice and takeaways would you offer to school boards about what we have learned and what we can expect and plan for going forward? It's a big question, I realize, but I hope you can give us some guidance.
Yeah, no, and let me do this. As with all things, I'll defer first to Heather on that question, and then I'll pipe in, because I think Heather has some very clear thoughts on how boards and districts can respond to what are some really meaningful changes in the way the federal government approaches local educational decisions. Heather?
Well, I guess didn't expect you to throw it to me immediately. I was dealing with the technology, but I think what we can expect is what we have seen already is going to continue. Past is prologue. So I expect that the focus on an insistence that federal laws and constitutional rights are in the Trump administration view, honored and enforced is going to continue. And we already know what those priorities are. They are essentially the 4 areas that we have identified in our agenda for today. And so I think what is important for school boards to understand is that to the extent you have policies that need updating, you should make those updates. To the extent you have current policies in place that may draw you into the orbit of enforcement actions, it is really important and vital that the school act as one, and that the policy decisions be made at the board level, that administrators are not the ones to deviate from those policies. Now more than ever, it is important that the schools speak with one voice. And if there is a decision to be made in terms of policy or politics, that it should be made at the board level. Is that what you're getting at?
And no, I agree with all of those things. But I guess what I would also add is that what I expect going forward is that the Trump administration's Department of Education, Office for Civil Rights, is going to be watching throughout this country to see who complies with their version of the statutes we're going to talk about in a few moments and who does not. And they have created a reporting system where community members can bring their concerns to OCR and the Department of Education. And I fully expect that they will be looking to make examples of anybody who deviates from their conception of what the law requires. Now, we're going to talk about what those are in some very discrete areas, but I think it's important that we all understand that we've already seen the start of it, and we are going to see more and more of it. There's an old saying that elections have consequences. This election, at least when it comes to Vermont education, probably will have more consequences than most. And we will all be watching, for example, what happens in Maine and places like that. My fear, of course, is that Vermont schools, where we are already under tremendous financial pressure, that pressure will only be ratcheted up by the efforts being made in Washington. So let's talk a little bit, Debbie, if I can, about the issues that we're here to discuss today. So the first issue that you saw on the title slide has to do with Title VI. And I don't mean to bore any of you, but Title VI is a civil rights statute. And what it says specifically is that if you are accepting federal funds, Vermont schools all are, so that is all of us, that you cannot discriminate on the basis of race, color, or national origin. And what that means in really specific terms is that no benefit or detriment can be based on anything having to do with color, race, or national origin. Now, for years, Title VI was based primarily on the concept that African Americans or Black Americans faced discrimination in the workplace, if they faced discrimination in schools and other institutions in this country. And this was a statute that was used to try and fight that kind of racism. And in many instances, successfully. The Office of Civil Rights was very focused on Title VI claims. It was aggressively pursuing those, were brought to their attention. But things changed not too long ago when the United States Supreme Court reached a decision in a case called Students for Fair Admissions versus Harvard University. Now, what was that case? That was a case where a nonprofit organization, the Students for Fair Admissions, challenged the practices at both Harvard and the University of North Carolina. Those universities considered race in making decisions around admissions. And what the people at Harvard and UNC argued is that it was important for their universities to have diversity of views and diversity of backgrounds when it came to creating student bodies, that is, admitting people into their institutions. And they relied on cases that had been decided throughout the years. SFA or SFFA argued that anytime that you use race as a factor, that it was unlawful discrimination. And in fact, the evidence in that case demonstrated that Asian Americans were disproportionately being excluded from admissions by virtue of race being considered. The US Supreme Court, after thinking about these arguments, concluded that in fact the lower courts were wrong and that the Equal Protection Clause of the United States Constitution barred consideration of race. So if we have a moment, let's think about the language. Heather, the next slide, please, in that Harvard decision. And here's some of the language that we saw as we read through the decision. The court rationalized by saying, well, we recognize that enshrining a permanent justification for racial preferences would offend the Constitution. This is something we have said for many, many years. But in some of our older decisions, what we suggested was that we needed to do something for years and years of what was clearly discrimination on the basis of race. And we needed to act in a way that gave affirmative benefits to the victims of that discrimination over the years. And that is this case Grutter that I have in the second paragraph. But the court in Harvard said it's been 20 years, and there's no evidence that this race-based admissions is ever going to end. That is not consistent with the United States Constitution, wrote the court. Such admissions programs must comply with strict scrutiny and may never use race as a stereotype or negative, and must at some point end. That's the court, what the court wrote. And that time, according to the court, was now. Now, that does not mean that race can never be considered. The court wrote, and I thought this was important, at the same time, nothing prohibits universities from considering an applicant's discussion of how race affected that applicant's life, the challenges, the discrimination, the hardships that had to be overcome to achieve the things that this applicant presented on documents submitted to the university. All of those things as an individual could be considered. What the court focused on this Harvard decision was making generalizations about people based on their race without looking at them as an individual. Next slide. So what did the Trump administration do with this? Well, they didn't lose a lot of time. The administration came in January, and by February, they were sending out letters called Dear Colleague letters from the Trump Department of Education. What they said essentially is that we believe that the Harvard decision, although based on the United States Constitution and not on Title VI, could be applied to Title VI. How? Well, any decision that is based on race is unlawful under Title VI, said the Trump administration. And in this advisory letter, something called a Dear Colleague letter from the Department of Education, the Trump administration wrote things like this: schools cannot assume that a person's race necessarily implies something about that person, including something about that person's perspective, background, experience, or socioeconomic status. Next slide. They went on to write things like these bullet points, right? A school cannot legally treat membership in any racial group as a plus factor. Plus factor, by the way, is one of the things that could be done legally under some circumstances before the Harvard case. Not anymore. And campus life, such as programming, graduation ceremonies, housing, based on those racially segregated, based on those race-based criteria, are legally indefensible, said the Trump administration. Distinctions between citizens solely because of their ancestry are by their very nature odious to a free people whose institutions are founded upon the doctrine of equality. And so what we see is the Trump administration is grabbing the philosophical legal underpinnings of this Harvard case and using it to put schools, colleges, and universities in the United States on notice that they will be aggressively pursuing enforcement against those schools if they believe that there were violations of Title VI. And finally, OCR issued this guidance. They're not going to tolerate overt and covert racial discrimination as they conceive of it. And I want to be clear, this is a challenging presentation to make. We live in a state where we have very different views than the Trump administration's views on how to handle inclusivity in schools. Nonetheless, we are here today because it is incredibly important for us to understand the world outside of Vermont, and that OCR, the Office of Civil Rights, is going to take an incredibly activist role and has already in enforcing this vision of what the law requires. And so, as you can see from this slide, the Trump administration is not only skeptical, but antithetical, opposed to any efforts to draw distinctions based on race.
So-
Next, go ahead.
Can I, all right, go ahead.
Please do.
I just wanted to ask the question, the ultimate question. So where does this leave Vermont schools? We operate in a state, as you have suggested, where we are very focused on and have made a priority for making sure that our schools are inclusive and have identified groups that have previously not been as represented in all levels and in curriculum and in leadership. So what does this mean for those efforts?
Yeah, I think what it means is that we need to be very mindful of the fact that if we are using race as a criterion in making decisions about who belongs to which organizations, who we hire, who we exclude, who we promote, what benefits we offer, then we will be in a position where potentially we are exposed to liability by OCR. And I do want to emphasize that you see at the bottom here of this slide, institutions that fail to comply with federal civil rights law may, consistent with applicable law, face potential loss of federal fundings. They are not joking. This is real. And we know that because we have seen, next slide, something that came recently that probably many of you already know about. The federal DOE sent this to all schools, and I know in Vermont, the Agency of Education signed for all of us, but that's not what they were looking for. They were looking for every district to sign this, and I will be unsurprised if sometime in the next few months, we hear back from the Department of Education that if we want to continue to receive federal funds, each and every district will sign this document. And if you're asking me why, what difference does it make? Because if you look at this, you go, oh, all it says is we're going to comply with Title VI and that Harvard decision. So what? We can do that. Well, the answer is because in the guidance below the actual certification, there is an indication that if you sign this document, and it is not true at the time that you sign it, in fact, you are giving preferences, in fact, benefits, or the opposite, right? Choosing to exclude or withhold certain benefits from groups based on race, whether it's because people have European backgrounds or because they are Black or because they are Asian, then you may be charged under the Federal False Claims Act. What? What is that? The Federal False Claims Act is a statute that allows the federal government and anyone in the community who wants to stand in the shoes of the federal government to sue you for punitive damages, for all the money you receive from the federal government, for attorney's fees, if you have violated the act, which has made material false statements in connection with collecting federal money. This is a document that is supposed to set the stage for exactly that. And when I say people standing in the shoes of the federal government, I mean people in your community who might say, well, wait a second, I know that there is an affinity group at the high school where only people of color are permitted to participate. And guess what? That would be, under the Trump administration's vision of Title VI, a violation of the law and potentially the basis for a False Claims Act against the district.
Let me just jump in here. I take your point that under the Trump administration's view of the law, but I think it bears noting that the Harvard decision came down during the Biden administration, and the Biden administration's Department of Education had issued guidance to schools in the United States, alerting them to the impact of that decision and explaining that affinity groups and things like that were now suspect and potentially in violation of the concepts enumerated by the court there. So it was not a simply partisan take on the law. That was already begun under the Biden administration's guidance.
Yeah, and all of that is true, and those are excellent points. The only thing that I would add to any of that is the vigor of enforcement by the Trump administration far exceeds anything that we have seen before, and the willingness to push this to a point where if you do not capitulate, that they will take away your funding. I think there is a willingness to do that to achieve their ends and their goals that we have not seen before. Would you?
Yes, I wanted to make clarity around the legal interpretation is not merely a partisan interpretation.
Okay, so the next slide, please. So this is the place, Debbie, where we ask you, or Sue, if there are any questions on the Title VI issues.
Yes, there is one question, and there was one that said something like, how do you know? And I don't know what that was referring to. So whoever asked that, if you want to send in a more specific question about that, that would be great. But I'm going to ask the first question, which you, I think, have touched on a little bit, but it says, can you please confirm whether this restriction on racial distinctions regarding programming would apply to things like social affinity groups, clubs, for elementary and middle schoolers? Would it matter whether it was a program during school hours or after hours?
Yeah, so excellent question. And I guess what I would say to you that if it is affiliated with any governmental agency, that would be us, right? Like schools. And if it is part of us, even though it is an after-school program operated by us, if it is a school-related program, it will be governed by Title VI. And if there is segregation on the basis of race, it will not be considered consistent with Title VI. It will be considered discriminatory. So the short answer is we are in a position now where we can have an affinity group for people of color, but anybody can go. Right? Like that's the distinction, is that we cannot now put ourselves in a position where we say only certain students get to go get the benefit of this group. You know, we can have a group that focuses on what it is like to be a person of color and how to support people of color in our schools. But what we can't do is restrict membership. And I hear from my friends in the education community that in some ways this undermines the very purpose, right? You know, if we have a group, an affinity group, and somebody shows up and wants to say, well, I don't like the purpose of this affinity group, I think this affinity group is offensive, we're not going to be able to stop that person from being a participant in the group. And so there is the risk that we can have people who are now no longer excluded from those groups, undermining the very purpose of the group. Do I expect that's going to happen all the time? No, but it is a risk that we must be aware of if we are going to continue to have groups like affinity groups to support certain kinds of students.
Or put in the positive, we need to be prepared to engage with those students in a way where we use those perspectives as learning opportunities and an opportunity for an exchange of ideas. What we can't do is, in the parlance that we have adopted by and large in the last half decade, make it a quote safe space that is immune from questions and pushback on those issues. We need to be prepared for and engaging on those issues. We can't simply just restrict membership and avoid the question.
Yeah, and you know, that's not the purpose of today's conversation, which is, you know, we're now brushing up against free speech related issues. But I just want to remind everybody here that the US Supreme Court has characterized public schools as laboratories of democracy. And we have to get comfortable with the concept that people are entitled to say things in schools that we sometimes violently disagree with, hopefully not using violence, that make us uncomfortable. But that is the price of living in a democracy and experiencing, in particular, a laboratory of democracy. Now, any other questions, Sue, that we should be responding to before we move on?
Yes, we have a bunch here. So the next one relates to what you were just talking about. It says, if an affinity group is not exclusionary, but just encourages affinity by race, would that be allowable?
Yeah, totally allowable, right? But the only thing we have to be mindful of is that we don't get to censor speech when people show up to this school activity and say things that maybe we disagree with.
With the exception of they can't be vulgar.
And they can't, like they can't engage in a way that disrupts the entire activity. But if there's a respectful disagreement and conversation, there's not much we can do to stop that behavior. That's the price of living in this democracy.
The next question asks if girls on the run could be a problem.
Well, so I know a little bit about Girls on the Run because I've had this question. And Heather, I'm gonna send it over to you.
Don't send it to me.
Yeah. So what I would say is this: it's a Title IX question. There are provisions in Title IX that specifically contemplate there will be single-sex activities, and so the question is for Girls on the Run, and I know a little bit about this. Girls on the Run, the question is going to be, does it qualify under Title IX as one of those activities? I think the short answer is maybe, and I just don't know enough about it to tell you for sure. What I would say is that generally speaking, most activities ought to be not segregated on the basis of sex, that courts tend to employ what is called a stricter level of scrutiny when dealing with where there is exclusion based on gender.
Yeah, and that question really does go to Title IX regulations, which govern when and how schools accepting federal funds can create sex-specific activities. This conversation you just completed was just making distinctions based on race, national origin, ethnicity.
Yep.
So we'll get to Title IX.
The next question is, how will they be monitoring us?
Oh, well, that's the fascinating part of this. So the Trump administration has set up hotlines, reporting mechanisms so that people throughout the country can, I don't want to be pejorative about it, but rat you out. And so if you're asking how they're going to monitor it, well, that's one way. Another way is if there are just general complaints that are made that sort of percolate their way up, that's another. And then the final is, sometimes we do things as school districts that are very high profile, that come to the attention of bureaucrats in Washington or in Boston or wherever it is OCR is located. And all of a sudden, we've sort of put a target on our back. And of course they see us and they begin to consider enforcement activities. And I'm not trying to be flip about this. I'm sorry. I just know that one of the considerations that I talk to clients about all the time is, how front and center, how high profile do you want to be around these efforts and activities that the Trump administration is going to seek confrontation and enforcement around. And the more we do that says, hey, we're not going to do it your way, the more they're going to focus on us, I expect.
Okay, next one is, I am concerned about other specific groups such as counseling groups for students who are from families of divorce or individual students who identify as LGBTQ that meet with a counselor.
Yeah, so remember, Title VI only goes to questions of race, color, or national origin. So if we're talking about sexual orientation, gender identity, if we're talking about status like divorced parents, I'm not concerned about those ever being considered a violation of Title VI. Sue, you raise the person asking the question raises a really great point. What is discrimination? Well, we discriminate all the time, right? Grades are discriminatory. We discriminate between people who achieve proficiency and those who don't. We make decisions around who it is that needs special services. But these are all lawful discrimination, right? And what we're concerned about here is unlawful discrimination. And those are really identified by specific statutes, both in Vermont and nationally. Title VI is this national standard that the OCR enforces.
Okay, I've just got two more, and then you can move on to the next topic. This one
Ah.
says, how would you suggest handling groups or individuals who use discrimination as an excuse for lack of funding and/or quorum of attendance to create a program?
So I'm confused, Sue. I don't quite understand the question and I don't
I
want to
don't
answer it
either.
wrong.
Maybe we can ask for, I'll ask for the person to type in a clarification on that question, and I'll go on to the next one. What if someone who is not necessarily a part of the group, I think they're talking about an affinity group, is rowdy and disruptive?
Yeah, I mean, that's really the issue. If they're disruptive, if they're disrupting the way the group is operating such that there's a meaningful disruption, then you can censor speech. You can say, sorry, like you're not allowed to do it, or at least not in that way. You can, in a respectful way, express disagreement. But what you can't do is behave in a way that undermines our ability to do the work that we're doing here, not based on the content of speech, but the way the speech is delivered.
Okay, we don't have any more questions at this time.
Heather,
So you want me to talk Title IX?
Title IX, please.
So those slides are at the end, so forgive me, gonna get to that. All right, Title IX. Passed quite a long time ago, 1972. And at front and center, it means no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination in an education program or activity that receives federal funds. So it's important to understand that Title IX is only about schools. Title VI has to do with all sorts of government activities, of which a public school is an entity of the government. But Title IX was specifically passed because of the scourge of discrimination in the provision of educational opportunities on the basis of sex up to 1972. And so the purpose of that statute was to eradicate that, to call it out and to say, the quid pro quo is if you accept federal funds, you shall not, on the basis of sex, offer or limit benefits, privileges based on someone's sex. It went on to also allow for and carve out a section that this does not mean an educational institution cannot maintain separate facilities for both sexes, toilets, locker rooms, shower facilities, or other activities like sports, which we'll get to. So just put that over to the side for now. Now, in looking at Title IX's protections, two administrations, the Obama and the Biden administration, sought to reconcile or at least graft onto Title IX protection for individuals on the basis of gender identity, not on the basis of sex, but gender identity. Now, their argument was that that is one in the same. And they sought to achieve that through Dear Colleague letter. Sound familiar? This is something that the executive branch will frequently do. As with the Trump administration, so too did the Obama administration in the last years of the second administration of Barack Obama, issued a Dear Colleague letter, which stated Title IX protects individuals on the basis of their gender identity, and therefore those individuals should be able to participate in the sex segregated spaces and activities that Title IX currently regulates and operates. You with me so far? So Title IX says you can't discriminate on the basis of sex, except in certain instances like bathrooms and sports. But where that happens, Title IX regulates the operation of that activity and space. And the Obama administration said sex should also mean gender identity. And so those individuals get entry into those spaces and activities. That was challenged. That guidance was withdrawn by the Trump administration that came in and said, we have a different take on what Title IX says. In both instances, I want to be really straight here. Those were executive branch interpretations of the federal Title IX statute. 4 years pass, Biden gets elected. Biden takes up Title IX's regulations, which breathe life, which is a little bit more serious than a dear colleague letter. Indeed, if accepted, a regulation is the law. Issued new regulations, which declared that Title IX's phrase on the basis of sex means on the basis of gender identity. This was immediately challenged. It resulted in litigation in a half of the states in the United States. And in one particular case, state of Tennessee versus Cardona. Cardona was the Secretary of Education for Biden. There was an injunction issued, something we're hearing a lot about in the last couple of weeks. Should nationwide injunctions be allowed? In these cases, they were more limited, but nevertheless, there was an injunction nonetheless, because there was the belief that ultimately what the Biden administration had done in those regulations was illegal. Why? Simply put, it was legislating from the executive branch. If you want to change and amend Title IX to add those protections on for gender nonconforming individuals, you need to do it by statute, not by writing it into a reg. The challenge that was brought was successful enough to get a preliminary injunction, which was then appealed by the Department of Education to the Supreme Court. And the Supreme Court unanimously said to the Biden administration, sorry, you lose. This was not a partisan decision from the Supreme Court. It was a unanimous one. They kept the preliminary injunction in place. And in December, that case at the federal district court level ruled, in fact, what we thought back in July, we now have decided on the full merits, having heard all of the information we need, not just in a snapshot, advance look, and we are ordering invalidation of the regs throughout the country. I tell you this background because it is that decision that laid the foundation for the Trump administration's movement on Title IX regulation and enforcement that we have seen in the last 4 months. This decision came down in the first or second week of January, and it stated, quote, to throw gender identity into the mix of this Title IX statute was not only not something that was supported by the text of the statute, but stepping back and looking at the purpose and meaning of the statute, the court ruled it would eviscerate the purpose of the statute. It is at direct loggerheads and cross efforts, cross currents. It's in conflict. So what does Vermont look like after Cardona gets handed down in January? Well, first things first, it does nothing and leaves untouched protections that Vermont law affirmatively, by the way, we do have a state law which goes the extra step, our Vermont Public Accommodations Act, to provide protections to individuals on the basis of gender identity. We do not rely on the state statute which protects on the basis of sex, which exists. We have a separate language which goes and gender identity. That protection provides protection in housing, employment, acts of discrimination, acts of harassment, and that all remains in place. So why am I talking to you about this? Because the Trump administration is more concerned not just with making sure Title IX is understood and properly expressed as it was in its view in the Cardona decision. But in states like ours, where we have affirmative protections that would allow and compel as a matter of law entry for gender nonconforming individuals into sex segregated spaces, the Cardona decision stands for the proposition of you can't do that. That affirmatively violates Title IX. Why? Because of that language I cited. It eviscerates the meaning. And so on February 5th, there was an executive order from the Trump administration that says, this is now the state of play. For many years, there's been a debate, does Title IX protect or not? But Cardona went even further and it said, not only does it not protect, but it is hostile to the notion of having access to those spaces merely on the basis of your gender identity. And for that reason, as the agency is the Department of Education, US Department of Education, as the implementing agency of Title IX, they will now here, henceforth, enforce Title IX and call out those systems, school systems, that are operating in conflict with it. Well, which would those be? Those would be the systems where their local laws, like ours, offer access to sex segregated spaces and activities, in their words, merely on the basis of one's gender identity. And to Pietro's earlier point, and here are the regulations, and I'm just going to skip through those. There was in quick succession after that executive order, announced investigations of San Jose State University, the University of Pennsylvania, the Massachusetts Interscholastic Athletic Association, Denver Public Schools. Why Denver Public Schools? To the questioner earlier asking what's going to get us into the line of sight, there was a very prominent press coverage of the Denver Public Schools making changes to access to bathrooms in its school system. Within weeks, the Trump administration had said, oh, we're going to go investigate you and make sure your operations are consistent with Title IX. And those were probably going to be the focus for a period of time. But then we had the National Governors Association meeting at the White House and the very now famous verbal exchange between President Trump and Maine Governor Mills, where there had been apparently previous conversation about this conflict because Maine's statute is very similar to Vermont's. And so what we ended up seeing in quick succession following that exchange were investigations of Maine by not just the Department of Education, but by the Department of Agriculture and Health and Human Services. 3 federal agencies investigating the operation of public schools in the state of Maine for failure to operate those sex-specific spaces and activities in compliance with Title IX. And one instance, the Maine University announced that they were going to stand down and change their operations, and so the enforcement action was stopped. But the Health and Human Services investigation announced findings of violation on March 17th and gave the Maine Department of Education and the Maine Principals Association 10 days to get into compliance. They refused. The US Department of Education investigated the Department of Maine and again found out of compliance and gave them until April 11th under a last chance to come into compliance. They refused. And so in both the Health and Human Services and the Department of Education's investigation of the Maine Department of Education, those were both referred to the Department of Justice pursuant to the statute you see on the screen, which says if there appears to be a failure or threatened failure to comply, and non-compliance cannot be corrected by informal means, which were those efforts to resolve that I just cited, there may then be a referral to the Department of Justice where they can take appropriate proceedings. And so too, they did that on April 16th. You may have seen with a great deal of fanfare, Pam Bondi holding a press conference announcing she was filing papers in the district court for Maine, suing the Maine Department of Education. And it's a very straightforward complaint. I have it on my desk. I read through it. Basically, it says you are a recipient of Title IX. You aver that you will comply with Title IX. You are operating your schools in a manner where there are athletes participating in sex-specific activities, sports that violates Title IX. We have given you multiple opportunities to get back into compliance. You have explicitly refused those efforts. We are now suing for a declaration that you're in violation. We're suing for a declaration that will stop your non-compliance. We are suing to have you compensate female athletes who were denied, quote, equal opportunities, damages to the United States, cost, fees, monitoring, enforcement. So this lawsuit is barely 6 weeks old. We are in early days with it. What does all of this mean for Vermont schools? What I would say is this: we are in a similar situation. Our state law requires that we provide equal access and opportunities to individuals on the basis of their transgender or gender nonconforming status. And so that bumps up against Title IX having essentially through federal supremacy gotten there first. Title IX creates a requirement that those spaces and activities operate consistent with Title IX. We've got the clear decisions of the court in the Cardona decision telling us what that effectively means. But what we don't have yet is a clear decision from a court that says, what do you do when the state law requires you to do one thing and the federal law requires you to do the other? However, that's not a new novel concept. We've had federal supremacy in this country for a very long time, and it's been used to great effect in order to advance progressive agendas, not just a conservative agenda. So here we are in this moment. I will now take questions on whatever you want to ask me about this. And Pietro,
Let me jump in just briefly on this lawsuit. We look at this list and of the relief being sought, and we go, oh, declaratory judgment, okay, no big deal. Costs and fees, all right, monitoring and enforcement, no. What really, from a legal perspective, causes me great discomfort is damages to the USA. What does that mean? That likely means the return of federal funds that were provided at a time where they were out of compliance. And if that is true, I don't know where Maine is going to come up with the money they've already spent that they received from the federal government. And I also know that if there is not an indication that they will come into compliance, there may be real significant issues as to future federal funds going to Maine. So we can all take a position on whether we agree or disagree, support or don't support the actions taken by the Department of Education in Maine. But what I guess I would say to you is that the potential risks, the ramifications might be extreme.
One other thing I want to note is here is the actual portal, ndei.ed.gov. That is that hotline that's been set up. And also in early April, this really caught my eye, another press release from the U.S. Department of Justice, which is the ultimate enforcement mechanism to ensure compliance with federal law. DOE investigates violations of Title IX. Typically, when they're done and they say you violated, they say to the school, here's what you need to do to get back in compliance. And all of my clients, whoever in that situation, says, yes, please, thank you, we will do that. But where you say, no, we won't, you get referred to DOJ. So DOJ announced on April 4th They are creating the SIT, the Special Investigations Team. This is from their press release, their language, not mine, amid a staggering volume of Title IX complaints. Title IX complaints? Complaints that school systems aren't in fact operating the way I've just described. The Department of Education and the Department of Justice are announcing a special investigation team to ensure timely, consistent resolutions to protect students, especially female athletes. This will streamline investigations to create a specialized team of investigators taken from both the Department of Education and the Department of Justice and apply rapid resolution investigative processes. This is going to be a fast track crack team that is going to be deployed in order to turn these things around quickly and to achieve results. The kind of results that you saw in the Maine case, most people would agree, most observers would comment and say what happened in Maine was incredibly quick. They are taking that as their model and they are going to replicate it and multiply it so that any and all investigations under Title IX are going to be processed quickly. I have cases from the US Department of Education's Office for Civil Rights on my desk that have been open for over 3 years. Typically, it's more like 1 year, but sometimes it goes longer than that. To have Maine investigated within 4 to 5 weeks with referral and filing by DOJ in court by mid-April was shocking. But I will tell you this, when I look at what they did, it's not that hard for them to do. Unlike the cases I deal with, which usually deal with students with disabilities, and there's a lot of facts to be developed, and we have to get into the IEP and whether or not certain services were given and what, it's not very clear what happened. It was all a matter of public record. Here's the policy, here's the student who participated, here's the track meet that occurred. You signed this affirmation that you comply with Title IX, but this is what Title IX really required you to do and you didn't do it. So it's very cut and dry. It did not require 2 years of investigation. It's all a matter of public record.
Questions?
Questions?
I do not see any Title IX questions. There is one that relates back to Title VI. So is it okay if I ask that one now?
Yes, please.
Okay, thank you. This is the one that we were trying to get clarified. The person says a group of 3 individuals wish to create a new program. Currently, there is no funding as well as low participation. There isn't really a question there, but I'm thinking the question might be whether the school must create that program, but I'm not certain.
Yeah, so that's not really, I mean, look, whether the school does it or not, that's a great board question or a great administration question. But I don't see a Title VI ramification for that. So that's not going to draw the attention of OCR.
Okay, I do not see any other questions at this point. Thanks.
Great.
So I
I'll
have, just to do a time check, Heather and Pietro, we
Oh,
have
dear.
2 more topics to go and 4 minutes left.
So let's do this.
Sorry,
Let me just riff very quickly on the question of immigration status and enforcement by ICE.
Can I stop sharing?
Yeah, you can stop sharing. We've spent a lot of time in Vermont worrying about this issue, and understandably so. We've seen that the Trump administration has ramped up enforcement of the immigration laws and has ramped up deportation of persons who they perceive to be in violation of those laws or here without the proper documents. I guess what I would say to you is that our subjective fears that somehow this is going to spill over into our schools has so far proven not to be true. I am not aware of a single incident where, and we represent most districts, I'm not aware of a single incident where an ICE officer or an immigration enforcement person has demanded entry into a school, where that person has demanded information about a student's immigration status or a family's immigration status as part of, their investigatory activities. And I would say this, that, there's a lot of energy around this concept of sanctuary schools. But when people ask me for my advice around these issues, my suggestion is this: we have been dealing with law enforcement for a very long time. It hasn't been necessarily around immigration status, but law enforcement seeks information from schools frequently about all kinds of things. The advice that we generally give, and it's the same advice I would give when it comes to ICE or other immigration status officials. The advice is this: we don't give out information that is protected by FERPA without a subpoena or a warrant. That information is confidential. It doesn't matter whether immigration status is part of it. And then secondly, just as importantly, we don't let cops into our schools. We're not a clearinghouse for the police. We don't give consent if they, for them to come and question either our staff or our students, unless it is an issue in the school and we need their assistance. Schools are places of learning. If parents have given consent and it's a matter of convenience and we know who's going to be questioned, of course we can make distinctions and draw exceptions. But mostly law enforcement should not consider the school a place where they can, with our consent, come in and either arrest or question our staff or our students. The final thing that I would talk to you about around this issue of ICE and law enforcement is that we sometimes forget that there is a statute called the Immigration and Nationalities Act. And it says essentially this: if there is any public official or public agency that prohibits the sharing of information with law enforcement around immigration related issues, it is a criminal offense, a federal criminal offense. Now, nobody has ever harmonized that language with FERPA. FERPA doesn't talk about exceptions for immigration status, but there is a risk that at some point the Trump administration is going to press that issue when it comes to schools if we have policies or procedures in place that say we do not cooperate with ICE. How do I know that? Because just yesterday, I received an email from a client where a grant from the federal government included that language from the INA, the Immigration and Nationalities Act. They are ramping this up. And, we refuse to cooperate with ICE potentially at our own peril. And, oh, by the way, what is the maximum criminal penalty? I understand it to be 20 years in jail. So with those happy thoughts, I'm open to any questions.
Okay, we have a couple more. This one goes back to Title IX. I believe this question is for an activity other than sports related. There are specific activities for girls like after-school clubs or end-of-year studies based on the fact that there are not many girls who are taking optional STEM courses or joining STEM clubs. Is data that addresses the lack of girls in these activities a justifiable reason for offering these girls-only activities?
I would suggest that you make sure those activities get vetted by council. There are specific regulations in Title IX that tell you how and when you can have a sex-specific activity. And there are requirements that have to be met. So I can't just do it on the fly because it's all very, case specific. I'd have to look at what is your activity, what is the purpose, and has it met the standard? But I will tell you that warrants looking at.
Thank you. Here's another Title IX. Can creation of gender neutral spaces circumvent issues related to sex segregated spaces?
Brilliant, and thank you. It's amazing you got there much more quickly than I did. It took me 3 months of staring at this and going, oh, if I take this puzzle piece and I put it there, it might actually work. Yes, Title IX regulates sex segregated spaces. So if you want to get away from Title IX, don't segregate it on the basis of sex. call it a restroom.
But let me say this, that if we are going to have some gender specific bathrooms, spaces, and some that are non-gender based, we are inviting a problem. I would suggest to all of us that the efforts going forward ought to be in creating non-gender specific spaces overall, right? Like bathrooms. At my house, we don't segregate on the basis of gender, the bathrooms. And I would suggest that that's the model that schools ought to be thinking about. That, we create, to the extent that there are multiple users, we create circumstances where privacy is protected, and that we do not segregate on the basis of gender at all. Because the minute we start talking about some that are gender specific, some that are gender neutral, then we get into questions about where they're located and are they as good? And that's just not an argument we want to have.
It should just be multiple and single use.
That's the best possible result.
But that doesn't solve the sports issue, and that I just have to put aside for another day.
Here's another one. Will the analysis/enforcement change once a state like New York or California is not in compliance?
No, I think the Trump administration would welcome an opportunity to bash New York or California. I mean, the size of the state is not going to have an impact. Like they're good lawyers to fight on both sides of this issue all over the country. I don't think New York or California will get a special deal.
All right, here's the last one, and this shows how beneficial everyone has found this. Can we have a follow-up to this webinar?
Happy to.
Anytime.
I think that's a great idea, especially because there's so many moving parts and it's moving so fast. I imagine that we could have a monthly webinar on this topic, right? Just to keep us all informed. We won't ask you to come back that frequently, but we will talk to you both about coming back at some point. And I just want to close by saying thank you so much, Heather and Pietro, for your time today. This was extremely useful. I hope that those that were on the call, on the webinar, had some of their more urgent questions answered. But definitely, I think a piece of advice the VSBA would give to everybody is when you do have a question, consult with your school attorney. They're your best resource for getting these legal questions answered. And we wish you all a very good rest of your day. And thanks again for joining us. And thank you, Heather and Pietro, for leading us on this journey of learning.
Absolute pleasure. Thank you so much for having us. Really appreciate it.
Take care. Bye-bye.
Bye-bye.